the time of obtaining completion certificate, since it's about 200.
What are you talking about?
That is what we follow.
That
Because
don't expose yourself, please. Don't expose yourself too much. Let him take instructions and come back. What is he saying has disastrous consequences. Mr. Vishas, sit with your authorities that is coming under. I don't know whether Mr. Mukherjee's client is interested to do business or interested to fight over in the court. Because this situation I cannot allow.
So, last occasion I produced the law that in respect of this construction is
8 units. You are on 8 units.
Every shop, every unit is a separate flat. No requirement of RERA.
He says so.
So this is not a says so.
Mr. Mukherjee, it is not subject matter when you are offering, because you are obliged to offer to the tenants substituted place after construction. You are a person who will be getting, you will not be satisfied whether the construction is legal or illegal.
So sanction plan is there.
Not on sanction.
That is a separate issue. So they can.
You are not possibly. You are in a mood to settle the issue. Otherwise, you cannot move.
Now, let's say one thing. Let's say last
corporation. You are the cause of everything. What steps you are taking? This kind of things. What steps you are taking?
We have given 411 notice requiring them to demolish. Thereafter, we didn't do anything. It's for them.
Why? Under 412A, you are obliged to. Mr.
It's a notice for self-demolition. We have given it. They continue.
What are you doing? Why are you shutting your eyes? The tenants are evicted. What is the purpose? 412A. What is the...
At the time of submission, I'm making a submission from record. At the time of the submission of sanction plan, they have given no objection of 10 tenants. During a hearing, we have found 3 of the tenants are raising objection. Then we cancel the first sanction plan. Subsequently, they
didn't cancel the plan. High Court, this honorable court, quashed the plan on the ground of fraud. What was submitting? Post you yourself with proper fact. Now, what is the court is requiring? Great, whatever you have done, it is a new sanction plan.
a new sanction.
Is a new sanction.
They have submitted this.
Are you not listening? Is it a new sanction plan? Have you obtained no objection from other tenants?
Your Lordship,
have you complied with the direction of Justice Sarkar?
Your Lordship, kindly see, this is it.
I will enforce the personal presence of your Montri and everyone. Please don't push me into that area. Who is pulling the string? You have given a dangerous building notice. Very well, 412. And you are totally blind towards 412A. Read out 12A. What is your obligation?
Initially, this.
You stop it. It is your obligation. You ask the tenant to come before you. Hear out. What are the objections? You have a statutory obligation to see the language. Why in 2022 to cover up these situations? 412A was introduced that the tenant's possession must be protected. It is your statutory obligation. The tenants are crying, shouting. You are saying, I have given. Today you will paste a dangerous building notice to any building, and the person who are interested to make money will demolish it.
In the entire exercise,
you stop it. I am not in time to hear it, but come with the records. I want to see the original records. Bring the original records.
And your Lordship then sees the notification. This notification says, applicability is RERA is required in respect of KMC jurisdiction when it's above 200 square meter. Whether it's 200,
Mr. Vishwas, it appears you are very much interested to protect this promoter within the corporation. What is the interest? What is the company's name?
Take developers. Query from your Lordship.
Take developers.
Since it was a query from your Lordship, I must.
Sir, bring all original records.
In that area, there are 6 buildings. They have touched 6 buildings in that area in central Calcutta are suffering under them. Others, tenants are not moneyed enough to approach the Honorable Court.
Mr. Bishas, bring your all original records and what the logic. RERA is applicable regarding not only area, unit wise.
Yes.
Two factors are there. Now forget about that. Why this court is inquiring? Because they are negotiating whether the tenants, displaced tenants, can be given effect. 12A says even he has to accommodate the existing tenants for which he will be getting the additional floor.
The introduction of 12A Malad is subsequent to
Maybe the building has not yet been demolished. Building has not yet been fully demolished. Don't say 12A is not applicable. That means your intention is very bad. What do you want?
We have all bona fide Malad. We will pause another.
You are an authority. Kolkata Municipal is not for the Sheikh promoters only. Municipal is not for the Sheikh promoters only.
Lordship, last occasion, Lordship, I sit with the Lordship.
Sit and find out a way.
Lordship, nobody turned down.
No.
Nobody. Lordship,
This is the full trouble. Kindly
see petition. Lordship, kindly hear me.
This can be breached out. This can be breached out. I am appointing an advocate of this court as a mediator between these.
Yes.
Right?
Yes.
No problem?
Yes.
Mr. Parthovodin Rai, come forward. And both of you has to pay to the special officer I will be appointing.
Yes.
Without remuneration of this business game will not be there.
No, definitely.
Lordship, only thing the petitioner is claiming the third party right because other tenants also.
Right,
He's
there are-
facing the claim that other tenants.
There are 6 tenants. They all wanted to see.
Mr. Mukherjee, who are before me, you are required to take out the issue before the special officer.
Yes. Obliged.
So petitioner is raising the voice on behalf of the last.
Not on behalf of anyone. I have 5 rooms.
Mr. Mukherjee, Mr. Roy will be there. You place your papers and your proposals.
Yes.
You place your papers and proposals.
Yes.
You want to do business, do business. Don't dig anything which will go somewhere you don't know.
But it's issue not. So we are trying to resolve this
you are
problem.
a businessman. You have come here to do business. The tenants are there. Whenever you cannot file a suit for eviction. Get a decree.
Yes. Get a decree. Evict.
Don't do that. Tenants are exposed by rent laws. Everyone is not very comfortable.
So far, I sit one day. I sit one day. So far, the version of the tenants.
Mr. Banerjee, you must be reasonable.
I am reasonable. But he has to do one thing. The promoter has only one thing. Only one thing. May I? The version of the tenants is, I am going to talk to you about only your tenancy and no other tenancy. Other tenants are wanting to come in and sit in a comprehensive negotiation. Now, when Mr. Roy comes in, subject to your lordship's appointment, all tenants will sit.
So why all tenants? Why not? Say for all tenants.
Their suits are pending. Their divisional applications are coming up.
Here I have objections.
I am telling you, lordship.
Let them come, then I will consider.
Yes. When they will come,
Let them come, then I will consider.
Very well.
And the Arjun.
So kindly restrict this issue that this settlement only in respect of 3
He has 5 rooms to give us.
Whoever before me, Mr. Mukherjee.
Yes,
He doesn't have 5 rooms in the
I am not going to, I have heard it, I have forgotten.
Yes.
Only good. The interim order passed in this, how many matters? All of it in these matters are extended for the
Common order, my lord.
is extended till the end of the month of August 2024. This court appoints Mr. Parthovodin Roy, a learned advocate of this court, to mediate the dispute between the parties. The remuneration of Mr. Roy for the time being would be 70,000 to be shared by the parties. Parties means not the KMC.
Yes, only the petitioner and opposition.
And the opposite party.
Private opposite parties.
Here all private civil division. Opposite party numbers
1 to 7.
Yes, 1 to 7. Or 1 to 7 in all?
I'll just except 1 to 7.
Or in all division 1 to 7?
Yes. I'm representing one
Only by the petitioner,
the parties.
petitioners,
Just
and
take
the parts number 1 to 7. The Mr. Roy shall submit his report on the next date of hearing. Try to work out a solution.
liberty to submit the relevant documents on
All. Find out the way.
Mediation, everything can be seen.
Is 23rd August. 23rd August, you are giving enough time. 23rd August.
Get some papers regarding the litigation.
Yes,
that's possible.
Parties are directed to hand over their respective pleadings to Mr. Roy. Stop. Mr. Vishwas, you may requisition Mr. Vishwas if necessary. Acha. The fees of the mediator shall be paid before the commencement of the first sitting. Next one.
Obligation.
I am appealing for the picture.
No, carry on.